Good afternoon to you and everyone. I'll get to the subject proper. That is the use of Portuguese jurisprudence presently practiced in certain parts of India. Now,
I did just a small announcement
yes,
before we begin. Participants, if you all have any queries, please feel free to raise it in a chat box or use the raise hand function. We will unmute you. Edrich, you may kindly begin.
yeah. The Portuguese jurisprudence presently it's applicable to the state of Goa and some union territories that were under the Portuguese. For example, Silvassa, Nagar Haveli, Daman, Diu. These are union territories which are located between Gujarat and Maharashtra borders. So in these areas were administered by Portuguese and they were ruling over there. So they used the Portuguese code, civil code, which is completely different from the law that we follow in the rest of India. The rest of India followed the British system because we belong to the Commonwealth, and we had what we call common law, but the Portuguese had a civil law. Now we should not mix the civil law with what we have the CPC. That is a separate issue altogether in itself. CPC is Civil Procedure Code of common law, but civil law is a law, separate law jurisdiction in itself. It is a code. The civil procedure, it is a civil code. It's consolidated law put together forming a code. Let us come back to what you call the Portuguese civil code is divided broadly speaking into four headings. Family law, contract act and testamentary proceedings and land laws. I will just give you an example of contract act, just one example would suffice. If we try to understand the difference between the contract act, Indian contract act and their contract act, there is a very wide difference. In fact, their contract act would be a piece of social legislation in as much as it incorporates certain unique features that takes care of supposing an old person, parents, children, young children, or otherwise somebody who's handicapped or something who has a disadvantage, that person should not be left at the mercies of others. You see, so in order that that person is not cheated or not brought out on the streets or doesn't have to eke out a living through begging or something. So these special features were incorporated in the Portuguese Civil Code, in the Contract Act. Their Contract Act is such that if you enter into a contract, let's take a contract of gift. Contracts could be of various types. Contracts could be of sale of property, lease of property, gifts, or various other things can constitute a contract. Now, let us take the case of a gift. Supposing an elderly person gives a gift to his young son or daughter, and that son or daughter neglects that old person, does not give him medication, does not give him food, ill treats him, or does some unusual act that brings misery upon that or some discomfort upon that person, then that old man who has gifted the property can take it back irrespective of the contract. This feature does not exist in Indian Contract Act. Now, somebody may question me as to why. In the Indian Contract Act, we have what you call donor and donee. The person who's giving the property is the donor. The person who's receiving the property is the donee. When a donor donates something, he makes a deed, he appends his signature. The recipient is the donee. The donee receives their appends their signature. Witnesses append their signature, and the registration authority, as you all know where contracts are registered, they are registered with the Register of Assurances. which are located in various cities. Then there are sub-registers and things like that. So when you go to the office of the sub-register of assurance and register that contract, once the contract is signed, the donor does not have an authority. He doesn't have any locus standi, you can say, to take the donated property back. The property transfers from the donor to the donee on making of an entry in an appropriate register. Now, the Portuguese Act is such that even if you make the entry, that entry can be reversed. And this is a statutory provision. Now, only recently, about 6 months ago, something akin to this has happened in India, where a gift can be taken back, but not by way of a statute. The right to take back the gift does not flow from a statute. It came through a case law by some High Court or Supreme Court. Therefore, there is a vast difference between their Contract Act and our Contract Act. Once we give a gift, we sign it, parties sign it, all concerned parties sign it, the recipient, the donor, the donee, and the register, the witnesses. Thereafter, I have no locus standi to take the gift back because I've got no right only to reverse the transaction. So did you get this? This is one aspect of. Now there are something known as land laws also. Land laws, let us make a reference to the land laws. Portuguese jurisprudence was prevalent, and in Goa, Daman, Diu, Silvassa, Nagar Haveli, Dadra, Nagar Haveli, as far as Goa is concerned, the Portuguese Civil Code has been amended slightly. I would want to take you to the land laws. These territories of Daman, Diu, Silvassa, Nagar Haveli, etc., had during Portuguese rule and continue to have special laws related to lands. Of course, in one sense, land always belongs to the state. State meaning a sovereign state. All lands in India belong to the Union of India, to the sovereign of India. All lands in China belong to the government of China. All lands in any other country belong to that nation as a sovereign. But there is another context in which it is to be comprehended. Lands, if you look at it, in the axiomatic context, all land belong to state sovereigns, but in a conventional and colloquial sense, ownership or title to land stand in the name of an individual, an institution, company, trust, etc. The latter being juridical persons. So in these areas where the Portuguese code extends, locals were given land at time as gifts. Sometimes it was given gratis. Sometimes it was given for service rendered. At times it was conferred a special favor. At times lands were leased by the government to people, and at times it was sold. All of these lands were known as Alvara lands, which were utilized and developed over a period of time, and the locals who occupied it in whatever capacity gained, so to say, ownership with adequate and appropriate entries made in respective revenue records. On attaining independence, Land Reforms Act of Silvassa, Dadar and Nagar Haveli, etc. were enacted in its application over those territories. In this chapter, we shall confine ourselves only to Portugal jurisprudence, to sovereigns of Portugal, which geographically extend to various colonies of conquest over the globe, commencing from 1850, when the first consolidated code was drafted by Antonio Ceberra, a judge of the Oporto Court of Appeal, who was assigned the task by the Queen of Portugal. He drafted a code which submitted to the Crown, which was subsequently revised by an expert committee and approved on 1st July 1867. It came into force on 23rd March 1868. So that is known as the Portuguese Code. The Portuguese extended their governance over a period over Goa, Bombay, and part of Gujarat. So these laws became applicable over there, wherever the Portuguese were ruling. But Bombay, after some time, was given as a dowry to the British. Therefore, the British law came into Bombay. The British law became applicable to Bombay. But in Goa and in the Union territories, up to independence, when I say independence, I don't mean independence of India. When up to independence of Goa, when the liberation took place in 62, up to such time, those laws were applicable and they continue to use the law up to date until a new law came to be formed by the state of Goa, and that law which was enacted by the Assembly of Goa was authenticated by the Union of India. It was endorsed by the Union of India. And therefore, today we have something known as the Notaries Act. When I speak about Notaries Act, I don't speak about, it is not to be comprehended in the context of the notaries that we talk about in India, that we generally talk about in India. Generally, notaries would mean doing notarial work. Their work has been defined in the Notaries Act. But when we say this the Notaries Act of 2012, 2012, the Notaries Act of 2012, then we are speaking about a particular act whereby a will of any domicile, any person domiciled in Goa has to essentially be sealed and registered. And there are a number of conditions that have to be complied with. And when the person expires after he is deceased, notices are to be put in various papers, notices are to be put at various sites, notices are to be sent to all potential claimants or heirs, inviting them to a particular spot, a particular office of a notary, wherein that document will be opened, that envelope will be opened in their presence. Adequate notice should be given. And if any party has not been given notice, appropriate notice, and that will is opened, that will negate the will. The person will be responsible for having breached a law. Now, this is to be done by giving notices everywhere. The notary makes the document, he seals it, he keeps it in the locker or with him. And when the party expires, he'll have to notify everybody to appear before him on a particular day and date and time where the document will be opened. In one important factor in this is that if the document is, if there is any overwriting, if it is smudged, if it is eaten by moths or otherwise spoiled in any manner, damaged in any manner, moisture or discolored or something, or is not legible, that defeats the whole purpose. If the envelope is opened even earlier, then prior to all the parties being present, that also will negate the document. So we have something as a Notaries Act for people who are domiciled in Goa. Now, this Notaries Act, in one way, it is helpful. People need not go to court to claim the legacy, you see, of the deceased. The Notaries Act makes it amply clear, and in fact, it reduces the probability of litigation. But of course, there can be litigation at times, but the probability of litigation decreases because it is very well set out procedure as to how to go about distributing the property. Another very salient and very nice feature of this testamentary proceedings is there is some similarity between the Muslim law and this law, in as much as which person gets how much has been prescribed in a sort of schedule. So you cannot exceed that. Parents will get this much, grandparents will get this much, great grandparents will get this much, up to the third degree it can be taken. Brothers will get this much, cousins will get that much, sons will get how much, grandchildren will get how much. All that has been tabulated. So the question of any sort of bickering has been reduced. The possibility of cheating also has been reduced, because It has been specifically drawn out how much you will get and who gets what. Up to 3 generations, literally, vertically and horizontally, it has been specifically prescribed how the legacy is to be distributed. Now, yes, I can take you to one more example of. I'll give you one example of of a very unusual situation that occurred with respect to property of some person who expired. The person was of Goan origin, living in the UK, having a flat at Malad and having some land at Goa. Now the person expired in UK. They had property in UK, property in Bombay, property at Goa as well. I mean, immovable property as well as movable properties. Now, how do you go about which jurisdiction is the appropriate jurisdiction to adjudicate this matter? The law is very clear. The will be open, will, if any, will be open in Goa only. The will have to be in such a manner as prescribed for testamentary proceedings in Goa. As I said earlier, the will have to be sealed, will have to be with witnesses, will have to be lodged with an advocate, kept in a locker, all these sorts of things. Notice will have to be issued, all that will have to come. So the jurisdiction will be Goa, even though the party lived in UK. And the Portuguese civil code will become applicable, even though the party lived in the UK. And the party had UK citizenship as well. But still, Goa law will be applicable. The reason being, one of the properties lies in Goa, and the person was domiciled from Goa of Goa origin. Therefore, the Goa law becomes applicable. Now, this matter went to, for whatever reason, there was whether there was an error or what. I don't want to enter into that aspect of it, but the matter went to the Bombay High Court, and at the Bombay High Court, it was admitted, adjudicated. A final order came to be passed. This is a very recent matter now. The party took that order and tried to implement it or execute it, we call it. The party tried to execute that order obtained from the High Court at Goa in respect of the land in Goa. Government authorities declined to recognize the order, even though it was from the High Court. So these are the dangers involved. You should know the jurisdiction as to where the matter ought to have been adjudicated. Since Bombay High Court has passed the order, the collector in Goa says, we will not recognize the order because the court ab initio never had the jurisdiction. Now your tricky question arises, and I don't want to say anything against any court or anybody, lest I am hauled up for contempt. But as a matter of intellectual exercise, in my humble opinion, the collector is correct. If a court did not have jurisdiction to pass an order, that order need not be recognized. Every order passed by every court is not necessarily binding on everybody. That is the legal position, as to my knowledge. I'll leave it at that. I won't say anything further. Now we should wait and watch and see what happens, because that matter is yet on the boil. Now, another feature that I would like to introduce to you is, let us assume a situation where an individual has taken a loan of rupees 1 lakh from a bank, and that 1 lakh is all he has. He has borrowed a sum of rupees 1 lakh, and his entire assets are valued at rupees 1 lakh. Assuming his house and other things, other property, car or whatever, everything is, just for an example, I say everything is total value is 1 lakh, and he has taken rupees 1 lakh from the bank as a loan. Thereafter, he expires just immediately after having taken the loan. Having taken the loan, paid a few installments and expired. So the other EMIs are balanced. Now the bank will seek to recover, any bank, of course, would seek to recover. Suppose he has paid 2 installments. Obviously, the balance would be, if there were 50 installments or 100 installments, they would have to recover the rest of it. Okay. Suppose 1 lakh was the amount taken, and let us assume he paid only 10,000. So 90,000 is recoverable, but that 90,000 cannot be recoverable due to the law. It operates by law. and not by contract. You might have entered into a contract with between the bank. The bank cannot recover the entire amount because the law enjoins upon any party to recover only 50% of the assets of the deceased. The reason being the other 50% obviously belongs to the other spouse. Unlike in India, all money can belong to a particular man and his spouse could be holding zero assets, or the spouse, the wife could be holding everything and the man could be holding zero assets. The law in Goa is such that on the expiry of any one of the spouses, male or female, man or woman, the other spouse essentially has 50% of the assets are reserved for that other person, so that the other spouse does not come on the streets begging, or the other spouse does not become a sort of pauper. It is a safety measure introduced by the law, taking into consideration various factors, various social factors. Is more of a social legislation, a protective legislation, where it sees to it that children are not become destitute, ladies are not left on the streets without in a penury condition, that you have nothing to fall back on. Therefore, 50% of the assets of any person, male or female, any married couple, cannot be recovered under any circumstances, even though they may have entered into a contract. For example, I told you about the man. He might have entered into a contract with a bank, taken 1 lakh, paid only 10,000, and thereafter died, expired. So the bank will lose to the extent of 40,000. The bank can recover 50,000. The bank can recover 50,000. You see, so the banking industry and such other companies should make note of this. And while advancing loans, it is an important factor to take into consideration as to what would be the recovery capability. In one way, it is a good piece of social legislation as far as the citizens are concerned, because citizens, if a husband dies or a wife dies, the other party is not left on the streets, or the other party is not a beggar, the other party is not insolvent, the other party is not handicapped, because it operates by law and not by contract. What operates by a statute will have an overriding effect as to what operates by a contract. A statute can override a contract, but a contract cannot override a statute. So these are some of the special features. Then I can give you about maintenance, family law. Family law again is a specialized subject for among these people. If family law even takes into consideration a child in the womb of a woman who is not born, but the fetus is of a few months old, that person also can be counted as a person. A fetus in the womb of a woman, for as far as dividing the share of the legacy of any deceased person is concerned. There are other safety measures which I will invite your attention to. Let us say I have left money in my will. I have explicitly said that this money, part of this money, or this money belongs to ABC on my expiry, or on my death, so after I expire, it is not necessary that ABC gets the money, because the law is such, even though I might have mentioned in the will, on my demise, this money goes to ABC, but the will not become operative if that ABC has ill-treated me, or not fed me, or not taken me to hospital when required, or attempted to kill me, or harass me, or assaulted me, or something like that. Automatically, that person who has indulged in such things becomes disentitled to a share of the legacy. So this is a very this feature we do not have in our common law countries. In our testamentary proceedings, in the wills that we make in India, this is absent. We may put money onto our children's name or grandchildren's name, or some brothers, siblings, whoever. And if that person ill-treats me, yet in spite of that, the monies go to him on my demise. So you see how it operates. They have it in their act itself. The law prohibits me from getting it. Here, people may have to fight it out to see that the person mentioned in the will doesn't get it. And a lot of things will have to be proven. A lot of things will be in animation, whether to go by the will or whether to go by the allegations. So these are the social legislations that have then dowry. Dowry, I wouldn't call it dowry, but I would say gifts and other monies or something that is given to either of the spouse becomes the property of both. Unlike in India, if you give a gift to a man, it stays it is addressed to the man and is presumed that it belongs to the man. If you give it to the woman, that's her property. And at the time of a dispute, when it goes to family court, she can ask for her property. He can ask for his property. But in Goa law, gifts that come during the wedding or afterwards is deemed to be one property. Unlike we have here, this is mine, that is mine. It is ours, and it will be divided accordingly. There is a procedure to divide it, equitable. So these are the good things that we have. The number of good things we should learn to pick up, good practices, and try to incorporate it in our practice. Then we have contract law. I've touched upon contract law. I touched upon testamentary law, family law. Also, I've touched upon. What I need to touch upon is we'll talk about the rights of property. The rights of property owners under Article 2169. When I say Article 2169, I'm not referring to any Indian law. The code has that many articles. Article 2169 includes right to enjoyment, right of transformation, right of exclusive enjoyment, right of compensation in cases of violation or damage, and right of alienation. Property has been classified into broadly two types, single and joint. Article 2175 classifies property as single and joint. Article 2176 rights of co-owners. A co-owner along with other co-owners may exercise all rights of single owner in proportion to the share he has in the common lot. So here, if there is a property, and if that property for some reason has to be divided, one person is not inclined to take it for whatever reason, or one person doesn't have sufficient capability of developing the property, or is not financially sound, or something like that, it becomes essential for him to sell his property to the other co-owners. Essentially, first priority is to be given to the other co-owners. Disposal of specific parts of common property. A co-owner, however, cannot specifically dispose of any part of a common property unless it is allocated to him in partition. The Panji bench of Bombay High Court has held in Josh Miranda versus João Miranda, also in Robert Coutinho versus Maria Botelho, that Article 2177 is not repealed by Section 44 of the Transfer of Property Act. So there is a conflict between Article 2177, if it is to be read in conjunction with Indian laws, we find that it is not repealed by Section 44 of the Transfer of Property Act, which is the Indian Act. So there are some gray areas where now coming to let me come to marriage. Marriage again is not recognized. Religious marriage is not recognized in Goa, be it Hindu, Christian, Muslim, Parsi, whoever. Your respective religion marriage is not recognized. Even Catholics are not recognized. The state doesn't recognize anybody's marriage. You, after getting married, you have to essentially register yourself. After your religious marriage, the same has to be registered with the state. And it is only the state marriage, the register of marriage, who registers the marriage. That marriage is registered in the eyes of law. Of course, people find a way to circumvent that by going beyond the borders of Goa, getting married and coming back. But that is how to abuse the law. We are not supposed to be teaching you that. Anyway, marriage, the state doesn't recognize anybody's religion. If your marriage is not registered with the state, it is deemed to be no marriage at all, as far as litigation is concerned. Yeah, that what I was discussing about 50%, there is a particular name for it. Legitime. Legitime. I was searching that. Legitime. Legitime. Legitime automatically gives all children without gender distinction equal rights in 50% of parents' estate by sheer operation of law. It is defined there. What is legitime? Legitime automatically gives all children without gender distinction equal rights in 50% of parents' estate by sheer operation of law. Now there is something known as disposable quotas. How much money or how much property you can dispose of? Because if suppose a person is a gambler or is a drunkard or something, he might just waste all the property, all his assets. So as a safety measure, there is something known as disposable quota. A person can under no circumstances dispose more than that. Disposable quota forbids parents from disposing by will or gift more than 50% of their estate, the balance being the legitime, which devolves on the children equally by operation of law of intestacy. Then I'll give you the other definition of the Notaries Act, where the wills are open. It is known as the Inventory and Notaries Act. Inventory is a summary proceeding to ascertain and allot the estate of deceased within 60 days. Here, any dispositions in excess of disposable quota can be set aside by the affected heirs. The deed of succession. Deed of succession is an even more summary procedure to identify and declare the heirs before a register. Till 1965, the assets could be allotted, could even be allotted, but now no, they cannot be allotted. Now there is something known as relinquishing the right also. One can relinquish one's rights, which is permissible in any estate. Now registration of wills. Registration of wills makes wills self-probated. Seen that? It makes it self-probated, obviating the need to file the cumbersome probate after that. Law of property. The law of property expounds the incidents of holding and enjoying property. Unlike English law, wherein only transfer of property is legislated upon, then there is something known as preemption. Preemption, I think that preemption is applicable even in our law. Preemption prevents a co-owner from selling his share without consent of others. Besides preemption between owners, there are other unique types of preemptions in the Portuguese code as of aformento. Aformento is a particular word that has been formulated. It speaks and describes about preemption. That is one form of preemption, but there are various other forms of preemption in the Portuguese code. Now there is something known as aformento or emphyteutic lease. This is a typical institute of European law. The land is supposed to belong to the government or to a public institution and is given on lease for a specific period. The lessee enjoys the property, but the title remains with the owner. The lease is transferable. The lease is also given, the lessee is given a chance to acquire absolute ownership by paying 20 years emphyteutic fees in a lump sum. Possession of property laws in Goa. Law relating to the right of property is a part of civil law. Civil law being the law which regulates rights and duties of citizens. In India, we have the Transfer of Property Act, 1882, which regulates transfers of property. But what happens in the property before and after it is transferred. These aspects of property law are authoritatively dealt under the Portuguese Civil Code, Part 2, Article 2167 to Article 2360. As no corresponding provisions exist in Indian law, all the provisions of Portuguese civil law are taken to be in force. But the provision of the 1867 code, for which there is a corresponding provision in Transfer of Property Act, stands repealed. However, in India, we don't have a law for holding of property. Therefore, in matters relating to holding, ownership, and possession of property, provisions of the 1867 code still operate. See, even though the Portuguese have gone, the law has stayed there. The law has not been repealed. That is the mistake that has happened. Certain laws have not been repealed, and if they have not been repealed from the statute, they stand on the statute book. That ought to have been ought to have been paid to that. Now, Article 1565. When I say article, I mean article of the Portuguese Civil Code, which prohibits sale to children or grandchildren, has also been held to be in force. You cannot sell things to your children and grandchildren, and they are not permitted to buy. As observed all through, the Portuguese Civil Code incorporates traces of canon law, where secular laws were blended with sympathy of the Catholic Church towards weaker sections of society, thereby acquiring a socialist tangent, inasmuch as it was envisaged and great care was taken in legislating so that grandparents, parents, children, grandchildren, spouses, siblings, relatives, and other stakeholders did not encounter losses or harm to their monies, estates, or other interest in the legacy of any deceased person, either by interstate testamentary disposition or contract, or by operation of law. Because if a person expired, all his property could not be attached, even though he owned individuals or institutions' debts, as legislation was drafted in a manner that safeguarded the interest of a wife or husband. Then we come to what you call a slight. I'll go at a slight tangent. It is something known as a uniform civil code. There has been a lot of talk about uniform civil code in India. Where uniform civil code is where the state doesn't recognize any sort of marriage or any sort of thing. Everything is on the same footing for all communities, all religions, all. So of recent time, there's been quite some talk where we are going to introduce the civil code in India. I think this is more of a misunderstanding. How can you introduce the civil code in India? It's already existing in Goa. In Goa, you have something not akin to a civil code, but a civil code in itself, where the state doesn't recognize marriages, religious marriages, unless they are registered. Then the state does not. Does not recognize so many other things. Just as a constitution brings political order, a civil code brings social order. It is also no coincidence that countries like France, Germany, Italy have their own civil code and are stable societies. Now, we have tried to incorporate for Article 44 of Indian Constitution, goes to the credit of founding fathers, where they have tried to introduce, but that is not mandatory. It was just suggesting that we implement this. But now the time has come when everybody, there has been a lot of hue and cry, and everybody wants a common civil code. By introducing the common civil code, it will be beneficial to everybody. In fact, certain people stand to lose from this as far as taxation is concerned, because the Hindu family is a Hindu united family, and they have special taxation provisions, HUF. So they will stand to lose to an extent. As far as the Muslims are concerned, they don't stand to lose on taxation aspect of it, but they stand to lose as far as the other matrimonial laws are concerned. Muslims never had a problem, whether you're Muslim or Christian or a Hindu. In Goa, all are equal as far as the legacy laws are concerned, as far as the matrimonial laws are concerned, as far as the land laws are concerned, all are equal. See, as far as the Contract Act is, there also all are equal. Only the criminal law is common all over India. But the civil law, as far as Goa and the Union territories are concerned, they have separate law. In Goa, Daman and Diu, right from 1870, a uniform Portuguese civil code prevailed. It has never caused hardship to the communities. In the case for civil registration of marriages, for example, the civil and religious formalities run parallel, and there was never a grievance in this regard. The Hindus of Goa have always been content with the Portuguese civil code, as also the Muslims, as far as the Christians, by a treaty between Catholic Church and the Portuguese government. The church had agreed that no religious marriage will be performed without clearance from the church authorities. Civil code covers not merely the personal laws of the community, but also property, transfer of property laws, contract, and law of evidence, and so on. So I think I have given you a brief idea of it. If there is anything you want me to specifically touch upon, you may say so.
Erich, can you shed some light on the Goan citizens, what you call the Goan residents getting citizenship of Portugal?
I'm not very familiar with it, but to my knowledge, it is you essentially have to be a domicile in Goa.
Okay.
I mean, for past 2 or 3 generations, you should have been in Goa. You're basically a Goan, whether you're a Hindu, Muslim, Christian, whatever. You have to essentially be a Goan from Goa, and you can claim that you make an application to the Portuguese consulate with all your documents, supporting documents, that you have land in Goa, you have properties, immovable properties in Goa, your generations have been in Goa, you studied in Goa, all these things, you have a bank account in Goa, all that. Then they consider you if you have been there for many generations. Not just anybody who has come down and settled in Goa. Because nowadays we find people
Domicile.
we find people who have come from Delhi or even Punjab and even Assam. They come and settle there for past just maybe 10 years or 20 years. That doesn't entitle them.
So just the birth does not entitle. It has to be that since generations.
Yeah, you have to have a few generations back.
Okay. And is this only applicable to the state of Goa or also to the other union territories, which were a
No, only
colony
Goa.
of the Portuguese?
I don't know about the union territories because they are following Goan law, but not exactly Goan law. Because after Goa got its independence in 1961, then there was an agreement between the government of Goa and the between the Union of India and the Portuguese, that they will accept us as citizens.
Okay. And how are the rent agreements governed in Goa?
Agreements?
Rent, yeah.
You make an agreement just like any other agreement.
As per which law?
The Contract Act, they have a Contract Act.
Okay.
So you make it according to the Contract Act. But their Contract Act is slightly different, where they can even rescind the contract or negate the in certain contracts, they can abruptly close up the contract one-sidedly. Because the contract is to be read in conjunction with certain statutes. So if it is barred by operation of a statute, automatically it becomes redundant.
Okay. And what are the practice prospects for young lawyers?
There is
in
great
this area?
great scope to practice, great scope, because very few advocates know this procedure and they have monopolized the whole thing. I'm sad to say that they have monopolized. People are at the mercy of those advocates and have to sit down in the offices, take 20 trips to their office because they are on dictating terms. Nobody else knows the law. Most of the people in other parts of India, students and all advocates, and including professors also, I haven't heard that such a thing exists.
Okay, so there is great scope, right?
There's great scope because it becomes applicable not only to Goa, to any Goan who is even out. Suppose the Goan is in Delhi and he dies. How his property is to be disposed is according to Goan law. He may be in Delhi or he may be in Punjab, but the manner in which his property is to be disposed is governed according to the go on law, Portuguese code.
Okay. At this, there's one participant. We're just unmuting the participant.
Yeah.
So I wanted to ask, how exactly do you establish whether a person is governed by the code? Is it that they are born in Goa or that their ancestors were born?
You will have documents now to show that your parents also lived there, grandparents lived there. Some documents you will always have to, where you have been voting or land, you're paying tax for land which you're cultivating. So you can always establish that I'm originally from here for up to 3 generations. That could suffice. You could be paying tax and all that for the land which you're cultivating or something, or some document you will have. Did I solve your this thing? Hello.
Sir, no. So if you're born in a different state like Maharashtra, for example,
Your,
then
ma'am, your
you're
voice
considered-
is very soft. Can you be a
Oh,
little
sorry.
louder?
if you're born in another state like Maharashtra,
Yeah.
yeah, then can you be, but your parents are of Goan origin, then will you be considered under the Portuguese Civil Code or under the Indian law? As long, or do you have to register your birth in Goa?
You have to register your birth and go. You should show your transfer at least there. That you have transferred from, you were born in Maharashtra, but you got it, you lived in Goa thereafter. And you are
Okay.
Goan descendants.
Okay, so domicile and descendancy is enough. Hello?
Yeah.
So your domicile and descendancy is enough. And my second question, sir, is you had spoken of 3 generations when you spoke about testamentary proceedings earlier in the
Yeah.
Notaries Act. By 3 generations, do you mean 1 + 3 or 3 generations?
It goes up to, what I would say is, if a property has to be, if some monies or property has to be distributed on the demise of a particular person, his father and grandfather up to great grandfather is entitled to a share in that. His son,
Okay, only up to great grandfather
yeah, and downwards it will come to son, grandson,
and grandson.
and great
Yes.
grandson, like this. And then it
Okay.
goes to brother on the lateral plane, it goes to brother, and then cousin. If brother has somebody, if he doesn't have children, then it will go to nephew or niece or somebody else. That way.
And with relation to Muslim law, is it like sharers and residuaries, or are they only sharers?
There is some similarity, but it's not identical to Muslim law. Muslims have the quantum of money to be disbursed is mentioned in their law. How much goes to wife, how much goes to the second wife, how much goes to
Yes.
the parents. Well, here it doesn't talk to you about the quantum. It tells you that how much. It won't tell you how much goes to you, but it will tell you that you are entitled to a share in that.
Okay, sir. So only that you're entitled, and then the advocate will make the calculation.
Yeah, there are various ways of calculating. It is a very consolidated code. A full detail is given on how to calculate various things.
Besides the code, are there any other books we can access? Like, I think, I don't know if there are any books on the civil code, Portuguese civil code.
I have written a book on that subject, which is.
Oh, you have? Okay.
Yeah, it's on Amazon.
Okay.
And, it's also available at Blue Rose Publishers, New Delhi.
So, and last question. You said affirmance is a preemptive, this thing. How is it preemptive? Because the leasee has a preemptive right.
I cannot pronounce that word properly, but I will say it's something like a tongue twister. Anyway.
Yeah, it's affirmance. That's how the locals say it. Is it a preempt? How is it preemptive? I just wanted to understand. Is it because the lessee gets a first right to buy it, or is it something else?
Lessee can get a right to buy the property. Or even otherwise, if there is a dispute between brothers and brothers, between the family itself, then the priority to sell, there are various type of this thing, preemptive modes. One way would be that you cannot sell to an outsider. Somebody is not in the family.
Yes, for the community.
But then there are various other types of preemptive measures. Some are operative by law.
Can you give some examples? Because I've never
Right,
come across.
right now, I might, I'll find it difficult because I'll have to go to the book.
Oh, it's there in your book.
Pardon me?
I will make it a point to purchase your book, sir.
I hope I've been able to satisfy.
Can you throw some light on bigamy, where a Hindu male can have a bigamy if certain conditions are fulfilled under the Goa Civil Code?
Biogamy, how will you call it biogamy? Means I didn't exactly get your question. You mean a Hindu male marry for the second time?
No. There's a Goa Civil Code.
Yeah.
I have read the newspaper
Hmm.
wherein a Hindu man have a right to a second marriage if the wife fails to deliver a male child by the age of 30.
Well, anybody can marry for second time. Even the Christians and Muslims and Hindus can marry for second or third time. The question will arise if they get married on the second occasion, how their assets are to be, they'll have to pay maintenance to the other wife. They will have to share their properties with the other wife because there are number of sometimes they have 2 or 3 wives. Then all 3 wives become claimant.
Yes.
And
Then
everybody will have to be given equal amount of share.
so 50-50%, how is going to be divorced?
The original the wife who can establish marriage, first marriage, and who can establish that she is the genuine wife in one context, originally the wife,
Hmm.
legitimate wife. She is entitled to 50% of that, what you call legitime, which operates by law, because 50% has to be given to one spouse. But the other wives who are illegitimate wives in one context, because after one marriage you cannot make another marriage. The second marriage can be performed, but it's a wrong marriage. Nevertheless, they are entitled to claim maintenance and share as well.
This is with context to the Goan Civil Code, right?
Yeah, the Goan Civil Code is just a civil code where your church marriage is not recognized until you get married, until the same thing has been sent to the register and he registers it. Then and then only government will recognize it.
And what about if a person who is domiciled in other state is buying a property in Goa? I mean, what laws are applicable to the other person who is domiciled in other states?
I told you are not allowed to buy I mean, you're allowed to buy property in Goa, but until everybody is willing to sell it, all the stakeholders are willing to sell it. If one of the stakeholders raises the objection, then you get stranded.
Who are stakeholder? I mean, what
Somebody might, suppose there may be four children, 4 persons owning the land. Either they will raise some objection.
So you are saying you must go with property who has the one single owner only.
Single owner, if he wants to sell it, he'll sell it. But if there is some objection, there can be various types of objection. Objection can be some lands are not permitted to be sold because they have been conferred as a gift by the government.
Okay, but Edith, suppose everything is clean, okay? So can a non-Goan domicile person purchase a land in Goa?
Yeah, many people have already purchased land.
And he's asking then which law will be applicable?
Obviously, Goan law only will become
Goan
applicable.
law, yeah. So
The
Goan law.
contract,
will be
when you enter into contract, it's a contract act.
Okay.
Unless if the contract act is not in conflict with any other law. Because if any other statutory law is there and it is in conflict, then that law will have precedence over the contract.
Okay. And can you please tell me the case name which you have given an example? I mean, the person who is a citizen of UK and has a flat in Malad.
And that is a client which it would not be proper to disclose the client's name because sometimes they may get offended. They may not like it pertaining to a particular client.
But any other citation that you had used, Edridge, that you can share similar?
Citation.
No, this is a very unique case. First time it's happened where the collector says,
Okay.
I will not accept the order of the court.
So I would like to know, is it advisable to have basic knowledge of Konkani and Portuguese to understand this law?
Come again,
Portuguese.
please.
Knowledge of
Like, do you need
Portuguese.
the knowledge of the language? Should
No,
one
no,
know the
it is in English.
Okay, even during Portuguese time, it was in English.
Yeah, they had some of them use Portuguese, but otherwise it is everything is in English. Proceedings are in English today in all courts, in all government offices in Goa.
Oh no, like if we want to take archives of original documents, maybe before
Then
61.
there are in Portuguese language. Some of the old documents are in Portuguese language.
Okay, but then it doesn't matter much. Like
There are
can-
people who are conversant with Portuguese because the old documents are in Portuguese, so we need translators and things like that. They are already there in the court.
okay, they are in court. Okay, sir.
There's an official translator. Besides that, there are unofficial translators.
Okay, sir.
So, Edridge, I think we are done with the questions. Thank you so much. It was a
should-
great session.
I should be thanking Plea.
Yes. So, Edridge, now there are many students here. Any message or any advice for the students?
There is great scope for litigation and other documentation work for advocacy. The wide field is open, which hitherto was not known to many people. Before I end, may I say that in Pondicherry, there is a civil code again there also, Pondicherry, but that is the French civil code. So just like we have a Portuguese civil code in Goa, Demon Dew, we have a French civil code in Pondicherry, which is existing even today. So you have good scope for business, for advocacy. Thank you, and thank Plea, thank Desai Foundation, and thank all the attendees.